Thank you, counsel. And on behalf of the probation department? All right. Thank you. The record should reflect that I've read and reviewed the respective probation reports prepared for purposes of sentencing in this matter. In addition, the record should reflect that Ms. Kinsey, on behalf of her client, has prepared a motion objecting to life without possibility of parole sentence as violative of the Eighth Amendment. The people have responded. I've read and reviewed those documents. In addition, today I have received some letters in support of Ms. Maraglino, and also I received some documentation as relates to requests for restitution in this case. Now, having reviewed those respective documents, is there anything else in writing that the court should have in hand in preparation for sentencing at this time? On behalf of your client at this time, Ms. Osby?
I filed a motion.
Which I'll address momentarily. Ms. Kinsey?
I filed I requested that a separate matter be filed under seal with the court, and if the court can receive that.
The separate matter under seal is under seal. Mr. Patton. Thank you. As relates to the request by Ms. Lopez, she has requested to continue the matter for purposes of probation hearing and sentencing. A 1050 has been filed timely in this matter. Any objection on behalf of the people?
No, Your Honor.
All right. With that, Ms. Lopez, you have a right to be sentenced to within 20 court days of the date of the conviction in this case. Understanding that, you agree to waive times. The matter can be continued until the date January 15th, as requested by your counsel, Ms. Osby.
Yes.
Counsel join?
I do.
All right. Then as to Ms. Lopez, the sentencing is continued for the purposes stated in the 1050 lodged by counsel until the date January 15th at 1:30 in this department. Counsel and client ordered back on that date, and at that time the matter is continued as to Ms. Lopez. With regard to Mr. Perez's open case, that's SCN 304604. Do the people have a motion?
Your Honor, given the sentence that the people will move to dismiss that case, the people would ask for a Harvey waiver and that the victim may at some point request restitution, so I would just ask the court to reserve restitution for the rest of that.
All right, very good. Any objection, Mr. Patton?
No, Your Honor.
Very good. And the defense agrees to Harvey waiver with respect to the issue of restitution?
Yes, Your Honor.
Very good. With that, people's motion to dismiss the open case, SCN 304604, is granted. That case is dismissed. Harvey waiver is to restitution, which will be reserved by the court. Now, as relates to probation hearing and sentencing involving Ms. Maraglino and Mr. Perez, I'll address first Ms. Maraglino's motion arguing that sentencing in this case would constitute a violation of the defendant's Eighth Amendment rights. Ms. Kinsey, any additional comments that you'd like to make?
No, Your Honor. I'm submit on my moving paper.
All right. Mr. Wong?
I'll submit on my moving paper.
Very good. Then, having read and reviewed the respective moving papers in the matter, I think the case law is clear that such sentencing in this matter, given the circumstances, would not constitute a violation of the Eighth Amendment, and thus I respectfully deny the defense motion. As relates to sentencing itself, Ms. Kinsey, additional comments that you would like to make?
So at this time, I'll submit on my brief and material that I submitted.
Thank you. Mr. Patton, on behalf of your client.
Your Honor, my position is that the 654 should apply in this case to all charges under the and so I would ask the court to find it on all charges concurrent with the exception of the conspiracy charge. And I would also ask the court to set the restitution fine, which is requested at this point at the amount of $10,000, at the amount of $1,000. I think that's a reasonable request under this particular case. And my client, Mr. Perez, does have a statement he would like to read to the court.
All right. Very well. Mr. Perez, I'd ask that with regard to your statement, you please take your time. When we read from a written document, we tend to speak more quickly. So please just take your time so that your words can be properly recorded. And please speak up.
I would like to take this time to thank my family and those friends that stood by me during this horrible and trying time. I appreciate your prayers, your love, and your compassion. I will never forget your kind words of encouragement. Those that know me know I have never raised my hand in anger at another soul. I'd also like to thank Mr. Patterson and Mr. and Mrs. Greenlee for their work, assistance, and aid. I have to apologize to all the families that had to suffer through these trials and tribulations. This is a tragedy in the worst case. The Joseph family, the Rest family, the Wall family, the Lopez family, the Perez family, the Tavares family, and especially to Lana and Jules. I'm truly sorry for your pain. To my friends and family, I will love you all, always. To those that at best turned their back on me, I have nothing but love and forgiveness for you. I forgive you all. Finally, to Mr. Espinoza, Detective Patterson, and to Judge Kirkman, Lamentations 3 says it most eloquently: to crush under one's feet the prisoners of the earth, to turn aside the justice due a man before the face of the Most High, or subvert a man in his cause, the Lord does not approve. Thank you.
Mr. Patton, anything more?
Submitted at this point.
Mr. Espinoza, first as relates to the application of Penal Code Section 654, the issue just addressed by Mr. Patton. Your comments.
Your Honor, we don't believe that there is a 654 issue. We ask the court to follow the analysis as laid out by the probation officer. I think it speaks primarily to whether the life sentence on the torture count can run consecutive to the life without parole punishment for murder with the special circumstances of kidnapping finding. I don't think there is a dual use here because the torture count, while it was a theory upon which the jury could reach a finding on the felony murder, we know by the true finding on the special circumstance that there is an alternative way that the jury could reach the guilt on the felony murder theory with the kidnapping. So therefore, it avoids the dual use, allowing the torture to run consecutive to the LWOP because the crime of torture requires separate mental states, separate acts than the underlying kidnapping for the target felony murder liability. And for those reasons, we don't think there is a 654 issue. We think that the probation officer properly analyzed the case, and we would ask the court to go ahead and sentence Mr. Perez to the recommended term of probation. Probation's recommendation, life without parole, a consecutive life term, an upper term of 8 years for the conspiracy count, with an upper term, with an additional 6-month term for 1/3 of the mid on the attempted sexual battery felony.
And then, were there any additional comments that people wish to make as relates to sentencing?
Your Honor, with respect to sentencing, there is a victim impact. The Rest family, the parents did not make the trip to attend the sentencing today. We have been in constant contact with them. They prepared a statement. Their request is that their statements be read to the court today, and Ms. Peggy Higgins is here and is prepared to read the victim impact from the family.
Very good. Ma'am, if you'd please come forward. And if you'd state your first and last names, please, for the record.
Peggy Higgins.
And if you could spell your name, please.
P-E-G-G-Y-H-I-G-G-I-N-S.
Ma'am, please take your time as you read the respective statements. Please speak up so that we can all hear. With that, anytime you're ready.
The first statement is by Colin Ress, the 9-year-old brother of Brittany Killgore. Your Honor, it was springtime and my sister Brittany was coming home. I just got a new video game and it was hard. She was good at video games and I like to play them a lot with her. Brittany promised to help me with the game when she got home. I was stuck. I love my sister and I miss her very much. I want her back. The people that hurt Brittany are bad and I hope they stay in prison forever. Colin Rest, Brittany's little brother.
Thank you.
Dear Judge Kirkman, it was January 2012, and we were standing in the Cleveland airport waiting for Brittany to board a flight back to California after a month-long Christmas visit. It was great to have our whole family together again. As I watched her walk away from the security checkpoint down the hall, I had a sinking feeling I would not see her again. However, that's just the butterflies every parent has when their children leave. I soon dismissed it as a silly, irrational emotion and went about my day. A few months later, and after much encouragement, Brittany was coming home to stay with us while she worked out a plan for her life. We spent weeks planning her move, arranging for travel, and having her personal belongings shipped. April 15th was the day I would see her again at the airport. Her sister Sabrina, who had become very close friends, as every parent delights in seeing, gave birth to a beautiful baby girl, Sophia Eileen, on April 11th. Brittany was extremely excited to get home and see all of us, but especially to meet Sophia for the first time. She had a few things to take care of, a few more days, and she would be home safe. As we know now, that did not happen. Instead, a few weeks later, we walked into a small viewing room at a funeral home to see a metal shipping casket screwed shut so that it could not be opened. After the trial, we all know why we could not view our beautiful Brittany. Many events imprinted in my memory about our loss, but repeatedly hugging a cold metal casket while trying to understand what was happening will be forever imprinted in my memory. I am given the chance to provide this victim's impact statement on how the loss of our daughter has affected my life. For several years, I have relished the opportunity to provide a statement, spending many hours thinking about what I would say, how I would say it, and whom I would direct it to. Mostly, it served as a therapeutic exercise to help me cope with the mental trauma I was experiencing. Now the time has come to prepare the impact statement, and through countless hours of thought, I have come to the only rational and logical statement I can conceive of. No words can ever convey the feelings, emotions, despair, and impact of losing a child in such a horrific manner. It simply cannot be done. Only a parent who has lost a child in such a manner could begin to understand. However, I feel as a victim cannot compare to the real victim, my daughter Brittany. Her life was violently and senselessly taken in her prime. I am her father, and as such, am supposed to protect her. I failed her. I struggle every day trying not to think of what she felt, what she was thinking. Was she in pain? Was she praying she would be helped? When will it end? Because if I do, I know I cannot mentally survive. I am trapped. I'm not going to go into what a fantastic, caring, loving, funny person Brittany was. Anyone that truly knew her or learned about her during this investigation already knows that. She had a quick sense of wit, too much for some with less self-esteem, and artistic talent, and cutting creativity. She was in the prime of her life, just starting to find herself and think about what she wanted out of life. My heart aches knowing she will never realize her hopes and dreams, never find true, unconditional love, and never experience the joy of having children and seeing them blossom into adults, among many other joys life has to offer. I have spent years trying to feel some sense of normalcy, and within the last year I have learned to function on a minimal level. I know I will never be as I was before, but as long as I do not think too much about Brittany, I will get by. Psychologically, that is troubling. I do not ever want to forget her, but it pains me to think about her. Certainly, we have been impacted financially by our traumatic loss, but this is the least of our trauma. We can quantify the direct financial losses we have incurred due to funeral expenses and lost wages associated with the legal proceedings. The losses untold are losses due to past and future wages because of the painful loss of our daughter. I was once climbing the corporate ladder as a highly accomplished engineering leader. Now, I simply want to work to survive. I have been unemployed for more than half the time since our loss occurred, simply because I cannot focus and perform as expected. The chatter is, I'm considered a high risk among colleagues and within my field. Time heals all, right? Law provides that the crimes the three defendants were convicted of mandates they will be in prison for the rest of their lives, never to experience a meaningful, purpose-filled life. Upon reflection, this is sad. However, that reflection is quickly broken and ripples away, like throwing a rock into a still pond when I think of the senseless, brutal kidnapping, torture, and killing of our beautiful daughter, Brittany. Such monstrous disregards for humanity and God's creation, then to attempt to dismember what God made and dispose of her as if she was trash. 12 fact finders and the law got it right. I assure you, if there is any possibility these three will see freedom again, I will be there fighting with all I have to stop it. Please ease my burden. Very respectfully, Darrell Rest. Your Honor, on April 14, 2012, I received a call that changed our family's life forever. We looked forward to having Brittany home. Her sister had just had her baby on the 11th. Brittany was super excited about being an auntie and could not wait to meet her niece. Brittany's brother, who was 5 years old at the time, was talking to Brittany about his new Ninja Turtle video game he wanted her to help him with. Britt never got the chance to meet her niece, and Colin never played his Ninja Turtle video game again, eventually asking to sell it. Colin has asked over and over questions we cannot answer for him. He's too young to hear some of the answers, and others are questions without a good answer. Darrell flew out to California on Sunday the 15th to look for Brittany and talk to law enforcement. We had to find out what happened to our daughter. On April 17th, I had to sit down and tell her sister Sabrina that Brittany was found. Then she and I sat down with their then 5-year-old brother to explain the unexplainable. I will forever have the horror on his face and in his voice when he realized Britt was dead and not coming home in my head. I then had to make the many calls to grandparents and many other family members and Britt's friends. I have dealt with so many emotions, trying to learn how to live each day knowing not only is my eldest daughter dead, but that she suffered such a horrible death. I think about how scared she must have been during her ordeal and death, and it still and always will break my heart in a way I cannot put into words. Brittany was just starting out in her life. She had turned 22 only 2 weeks prior to her murder. She was in an unhappy marriage that was long over. She was ready to figure out what the next step in her life would be. I mourn all that was lost, all her dreams and hopes, all of her dreams and hopes for her. I miss her laughter and her quick wit. I miss that we will not experience another time with all of our family laughing and having fun. I miss that we will not watch Britt and her siblings growing together, and Brittany being the great auntie to her niece and now nephew she would have adored. I and all who truly knew Brittany and loved her are blessed because there is not another out there like her. Brittany has grandparents and aunts and uncles that will always miss her and will be forever affected by her murder as well. She has many friends, some she's known since elementary school, that will always miss her. Brittany was very loved by many and always will be. I am glad the three monsters responsible will spend the rest of their lives in prison so they cannot harm another innocent person. It is hard to quantify by words how this one act has damaged and changed our lives forever. I will never get over my daughter's brutal murder. I will always wonder, what if? I will always wonder many things, and there are 4 people with the answers. My daughter Brittany can no longer answer them, and the other 3 are liars that sat for weeks listening to horrible testimony as we did, and one who sat on the stand for 2 days. We saw tears for each other and for themselves, but no remorse, nothing for our daughter, who they all 3 knew exactly what happened as they all kidnapped, tortured, and strangled the life from her. These 3 monsters saw her fear, saw her tears, cut her, threw her out like garbage, and sat in jail and in court time after time as if they are victims. Brittany and her family and friends, as well as their families, are the victims of their horrible choices. I thank you for the court's time, and I ask for the mandatory sentence of life without possible parole for all 3 defendants to be upheld and served. To the 3 that murdered my beautiful daughter, I ask, was it worth it? Was it worth taking my daughter's life and now losing your daughter? Was it worth taking my daughter's life and spending yours behind bars? I hope that each day in prison is miserable until you draw your last breath and you are shown the same consideration and concern that you showed to my daughter by your fellow inmates. May God grant you forgiveness, because I cannot. Thank you. Michelle Rest.
Thank you, ma'am. Mr. Espinosa. With that, on behalf of the probation department, any additional comments?
No, Your Honor, we submit.
For pronouncing sentence in this case, judgment in this matter on behalf of your client, Ms. Kinsey, wavering for judgment?
Yes, Your Honor.
Any legal cause?
No.
Mr. Patton, wavering for judgment?
Yes, Your Honor.
Any legal cause?
No, Your Honor.
Ms. Kinsey, any additional comments on behalf of your client?
My only comment would be, I read the probation report's request for restitution, and I'm fine with that. We did receive an extra copy today. Haven't really had the chance to analyze that, and I asked for any order in regards to that be set for a restitution rate.
Very good. Mr. Patton?
I agree, Your Honor. We don't have any documentation supporting the request, and there may be objections to those requests.
You submit on the request that was made in the probation report?
As it relates to the funeral expenses?
Yes.
Yes, Your Honor.
Very good. Any additional comments?
Just one other thought, and is that depending upon the court's decision as to whether there's going to be a consecutive determinate sentence, then I think 4019 credits would apply to that determinate sentence if it's run consecutive. And that has not been addressed in the probation.
All right. Did probation want to address that with regard to the application of 4019 credits on any consecutive sentence? All right. Mr. Espinosa, did you want to address that issue?
Your Honor, since it's consecutive to the murder count, and I'm entirely correct, it's on the murder, I guess they should move whether it's an LWOP, so that determine the time after the LWOP. I don't think it'd be entitled to corrections, but determine a portion of the indeterminate sentence.
And the court's position is that I'll apply the actual credits to date, and if in fact a modification is required with regard to any any determinate term charges, any indeterminate charges the defendants are being sentenced on today, then the appropriate modification would be made. Mr. Patton, anything? All right. With that, with regard to Mr. Perez and Ms. Maraglino, probation is denied. Each of the defendants committed to the California Department of Corrections for the term of 1 life term without possibility of parole and a consecutive life term. As relates to determinate sentencing in this case, pursuant to 1170 and 1170.1, the court imposes 8 years as relates to count 2. As relates to count 3, I make the observation Penal Code Section 654 does have application imposing an 8-year term, but staying that term pursuant to that code section, then consecutive to that term as relates to count 5, 1/3 the middle term of 6 months, total the term 8 years, 6 months, consecutive to the term imposed as relates to count 1, consecutive to the term as relates to count 4, Penal Code Section 206, that being the life term. I take into account in applying the respective terms in this case, Rule 4.421A1, 4.421A8, and also 4.421B1 as set forth in the respective probation reports. I also take into account application of Rule 4.425A2 as relates to addressing whether the term should be consecutive in this matter. As pertains to Mr. Perez, the credits are 1,314 actual days, and with regard to Ms. Maraglino, 1,289 actual days. No days credit for either as relates to the indeterminate terms pursuant to Penal Code Section 2933.2. The court orders restitution pursuant to Penal Code Section 1202.4b, restitution fine of $10,000. The court security fee in this case will be $200, a separate restitution fine imposed pursuant to 1202.45 as well. The court security fee, as indicated, $200. The immediate critical needs account fee is $150. The criminal justice administration fee is $154. The sex registration fee is $300. Restitution order pursuant to 1202.4F to the Victims' Compensation Program in the amount of $5,000, referencing the claims set forth in the probation report. Restitution in this case will be joint and several with regard to each of the defendants. Fines, fees, restitution shall be paid forthwith or as provided in 2085.5. The defendants to submit to DNA testing pursuant to Penal Code Section 296 to register as sex offenders pursuant to Penal Code Section 290. Reiterating this relates to count 1. The court imposes a life without parole term given the special true finding as to the special circumstance, and the consecutive life term is to count 4, the PC 206. Each of the defendants have a right to be present during the course of any future restitution hearing. There will be requests for additional restitution, and that has been made. Ms. Maraglino, Mr. Perez, you have a right to be present during the course of any such hearing. Do you wish to waive your presence, allowing counsel to appear on your behalf? Ms. Maraglino? Mr. Perez?
Yes.
Respective counsel join?
Yes, sir.
We'll have the record reflect waiver of personal presence as relates to each of the defendants for purposes of addressing any additional requests made for restitution. And my thought is we can address with the waiver of presence informally a future date that will be convenient for all. Now, we do have a future date calendared as relates to Ms. Lopez's sentencing. Perhaps that date is convenient for all on the issue of restitution, January the 15th, 1:30 this department. If it is, we can calendar that date. Again, we can address that informally if you wish. I believe that there is an additional request as relates to a property that is presently being held in this case. Mr. Wong, did you want to address that issue?
Your Honor, just with regards to that, I will get in touch with the victim. I'm not sure if he will be seeking to return the property, but if it does become an issue, I can address it on January 15th once I contact the victim. But I think at this point, I would prefer to contact you first and deal with the gentleman.
And I understand that there may be some additional requests as relates to the return of particular property. Let me ask respective counsel, to the extent that a request is made to return property, do the parties agree that the matter can be attended to informally with a submission of a proposed order to the court, to the extent that there's no objection by any party? First, on behalf of the people?
Yes, Your Honor.
And then on behalf of your client, Ms. Osby?
Yes, Your Honor.
Okay, and your client, Ms. Kinsey?
Yes, sir.
And Mr. Patton?
Yes, Your Honor.
Okay. All right, and we'll address that again informally if there is agreement. If there's not, why, then we'll set a formal hearing date, and we can address this with your client present on the date of sentencing, Ms. Osby. But Ms. Maraglino, do you waive your presence for purposes of addressing any motion that may be litigated regarding a request to return property? Mr. Perez?
Yes, Your Honor.
Counsel Join?
Yes.
Very good. We'll show a waiver of personal presence for that purpose as well. All right. Is there anything more that the people wish to address at this time, Mr. Espinoza? And then on behalf of your client, Ms. Kinsey.
Just, I'd like to, for the record, lodge an objection to the consecutive terms to the right to that parole sentence on the grounds of the 8th Amendment 654.
Duly noted. Thank you, counsel. Mr. Patton?
Okay, additional order.
Very good. Then we'll take a recess at this time. We are in recess. Thank you. Give you 1 minute. Counsel, one additional matter. It is my duty to advise each of you have the absolute right to appeal from the judgment of this court in imposing a sentence today. This means you must file your appeal within 60 days. The notice must be in writing, signed by you or counseled by both of you. It must specify what you're appealing from, whether it's the whole judgment or just part of the judgment. If you appeal and do not have the financial ability to retain the services of counsel to represent you on appeal, the appellate authorities will appoint counsel to represent you. It will be necessary for you to advise counsel of your location in the Department of Corrections system to keep them apprised of your location, your whereabouts. Thank you. And we're off the record.